The theme of my talk is about good practices in IP clearance in video games. But before I jump to the merits and to introducing myself, I'd like to make sure that we are at the same page with the situation I'm going to speak about. So I call this news from 2021 as bad scenario number one. I don't know how much you are familiar with this case that took place on the US market when Take-Two Interactive has addressed the legal claim. Actually, it was the objection about, against the motion to register trademark being a game title of Hazelight Studio. Hazelight Studio was about to release the game under the title It Takes Two, and they attempted to register this title of the game at US office as a trademark. So Take-Two Interactive has objected against that successfully. So I will come back to this topic just to draw your attention to another case that I call another bad scenario. This was a case from 2018 when the studio called, as far as I remember, 3D Realm was producing a game which was a shooter, and the title of that game was supposed to be Iron Maiden, which came with legal action, which faced legal action of lawyers from heavy metal, British heavy metal band Iron Maiden, who has addressed a claim of $2 million against the producers and publisher of this game. So, as the result of these two bad scenario situations, the producers and publishers of these games had to change their plans, an idea about the game they were about to publish, and actually they had to do it in the last moment because this case, in fact, has finished with releasing the title, although the producer had to issue their motion to register has been withdrawn. They didn't go out with registration of trademark on US market. Moreover, they released abandonment notice 1 day before the day that their game was going to be launched on all platforms. And in this case, the game was issued under different title. The new title was Iron Fury. From the perspective of the studios, these scenarios finish bad to the game production and release process. But from legal perspective, these are two examples of situation that, in my opinion, the IP clearance process didn't go as smooth as it should probably on the earlier stages. So to introduce myself in this moment, because I'm the Polish lawyer who is actually dealing a lot with IP clearance in video games, since I'm running a law firm in Warsaw, being registered as the Polish advocate, but as a team, we are working a lot on international markets, usually with our clients who are releasing the games to the European Union and US market, and helping and supporting our clients, both investors, publishers, and the producers of video games. We do lots of IP clearance on daily basis. So I would like to share in this place. I would like to share with you some good practices about IP clearance in video games. But I prepared these questions, hoping that there will be some more audience from the developer side, and I would like to have some discussion. How are you approaching IP clearance, and who out of you is maybe somehow involved? If you would like to share these questions, I will be grateful. If not, we can skip it. But if maybe just by raising hands, who among you is dealing with IP clearance in video games? Good, majority. Is there anybody who doesn't know at all what IP clearance is in video games? Nobody, okay, all pros. Okay, and how you associate IP clearance with, I know it's a reverse questioning, but maybe you would like to share some ideas already at this stage. Yeah, pretty to the point. Yeah, so I will provide you my answer, my understanding on this question on another slide, but I would like to start with some background. So again, let's go one step back and a short introduction why we consider IP clearance in video games, yes? So as we all know, video games production is basically based on IP, yes? And that's a fact, so period. Video games production is based on IP, on intellectual property of others. As we know, non-studio is able to produce its own IP. As we know, IP, especially once we speak about the works and everything that is copyrighted, it has to come from humans. So humans who are creators are being protected by IP laws so that their works, their property is not being damaged, used in an unauthorized way by others. And all this video games production involves contribution of multiple people. This is just a sample list of them. So just imagining what the creators of the huge venture that is video games are creating, we may end up already with the conclusion that there is a lot of stuff to clear. Since two aspects I have in my mind. First of all, that all this intellectual property is under protection of proper provisions of law. And secondly, because nobody creates in vacuum. So everything is interfering with everything, and it's very difficult to be really original nowadays. And having this in mind from legal perspective, we are already to the conclusion that having on mind such a big venture as video game production, we should be extra careful and aware about determining and verifying which assets and which IP we are using to the production, especially in those situations when the producers and the gaming market participants are aiming to create the video games as realistic and as surrounded and as based in surrounding world as possible. Very often the games are corresponding to the reality. Very often they are as grounded as possible. So that brings lots of tricks and difficulties that the game creators should have in mind when they create and release their titles. So this is a proposition, my proposition, how I would understand IP clearance in video games. So, first of all, I understand this as a process. And I will come back to this idea at the later stage of the presentation. So that would be a process where we are finding out whether IP, considered as IP laws or IP as the creations of others, are not going to be a problem to our future venture. I mean, our future venture, I'm putting myself in the position of the studio that is producing the game. So, yeah, and why we do that? I don't want to sound like a lawyer, but I am a lawyer, and I think everybody is lawyers as well. But I believe we do that to minimize the risk, yes. And then we are coming back to the very practical aspect, because which risks we are in fact trying to minimize, minimizing or eliminating. The risks are actually very practical, because we are trying not to put our clients to be a losing defendant in the IP infringement lawsuits. That was the bad scenario number one. Actually, that was not maybe a lawsuit, because it was a claim just addressed. Or we are trying not to end up as a studio to be this video game producer that is forced to take his game off the market, or to change in the last moment relevant aspects of the game. So the stake is quite a big, and definitely it's spotted by the creators of games, and of course the lawyers. That's our daily job. So I would jump here to the examples of IP in video games, just to brief and to map what we are speaking about when how I consider my daily job helping in IP clearance in video games. So what types of IP in video games we are facing every day? Most of them are works, yes? And as we all know, the works appear everywhere in video game productions. This is one of the example of the works. In fact, this slide comes from merchandising assets, but as we know, it can be everything. Also, artistic performance is type of this IP in video games that is subject to the clearance. And of course, trademarks. On trademarks, I will focus a lot during today's presentation, because they are really tricky, and then they can be very dangerous. So we need to keep them in mind. But I was thinking how to approach the topic to be maybe not that theoretical, but approaching it more from the perspective of the studio that is creating games. Because when I look at our clients that we work on a daily basis, we scan the process, how they, in fact, where do they take the IP for their video games from. And for the purpose of this presentation, I would categorize these sources into three groups. The first one, and they are of course interfering with each other, because usually studios combine these three methods all together. But definitely there are some assets that are coming from the creators that are hired by studios, so we call it like IP that is created from scratch. This can be code, definitely. It can be 3D content, like concept arts, scripts, some music, and so on. We also have in video games assets that are procured from ready-to-use base stocks or libraries. This can be fonts, sounds, also 3D content, or even metahumans. And then we have content that comes from the collabs with the partners, especially when we are joining different universe to ours, or when we speak about the purposes of merchandising. So having these three sources of the assets that are coming to the game, we can think how to approach the IP clearance process on top of these assets. And of course, since we are speaking about acquiring intellectual property rights, we need to have in mind the contracts, yes? So contracts are a must-have, and this is what all lawyers are doing on a daily basis, making sure that the clients are safe with the acquisitions. So we check contracts in all three categories. In fact, they are just different contracts. When we are checking the contracts with our creators, as we know, these contracts are have probably the most extended size. and the IP clauses are very specific. We make very due diligence. We put lots of care and our best due diligence to make sure that the acquisition will be not only fitting to the purpose and will be giving as broad usage as is necessary, but most of all, we are also taking care that the acquisition will be in fact effective. For example, in Polish law, we need to have a written form to acquire economic copyrights to the works, which means, and which is not very well understood, but still by all the participants of the market, that we need to have contracts signed or with ink or with qualified electronic signature. I'm still today meeting lots of situations where people are just exchanging scans of documents signed with or real or facsimile or DocuSign implemented signatures, which so happens under Polish law doesn't fulfill the obligations of the laws, and the pain is the nullity of the acquisition, so it's quite painful. When we are speaking about IP clearance of the assets that are procured from stocks and libraries, of course, we are checking very well the conditions that are set out in terms and conditions or licensing agreements. We are checking if the purpose of the usage is matching with the licensing conditions. And when we are speaking about the contracts with our partners on collabs, we are also checking the licensing clauses and the commonly agreed purpose of the usage of the assets that are under the cooperation. But what I wanted to put as the extra important aspect on top already of these 3 different sources of acquisition of IP is to always check databases of trademark being or national or European or on the territory level which the game is intended to be released, because it may happen that your content in fact will not fit for purpose. And an interesting example of this situation that we are facing in practice is situations where we are speaking about collabs, because it's very easy to imagine a situation that your partner that you signed the collaboration agreement is in fact present on different market, and his universum is different than the one that you intend to use the assets. So as the example, imagine your partner is the author of the comics, and you are going to license his feature, the main character, and the universe as well, and the names. And even in case your partner has the trademark that is registered for those assets, it may happen that the area of the protection given by his registration is not covering at all the area that you intend to use the asset. Meaning, happens very often that given name is registered in trademark databases, but not by your partner, but some other participant of the market. And in such a case, your plans will be, if not destroyed, at least requiring some modifications. Okay, so that would be a moment I'd like to make to share some insights which I have divided into 5 groups, like how this theoretical background of the IP in video games and its legal mapping together with the purpose of IP clearance, how they are matching together to give some tips, to share some good practices once we speak about IP clearance in video games production. So the tip number one, I would say it's not really legal, but it's more like management of the process. Because I like the approach that we consider IP clearance in video games, but IP clearance in any area that we are working with. First of all, as a process, and then as a process that is subject to management, and also the process that is subject to the risk assessment. It may be surprising, but being even a lawyer, we understand that we are not like, that IP clearance is not only about IP clearance and about the claims and about the risks and management of risks and so on. I believe that each client, each studio should first of all take the decision how they wish to approach this risk. And this assessment, because it's impossible, probably, to minimize the risk up to zero, like any legal risk of legal liability, theoretically the risk always exists. It's the issue how you will approach it and how you manage and how you assess it. So I think it's good to start and to have the understanding that this level of IP clearance should be related with the needs. And needs are always provoked by the current circumstances, as well as this IP clearance process should be proportional to the scale of the business. So coming back to these examples from the beginning of this presentation about these bad scenario situations, I would say that having in mind the circumstances in which these cases happened, it could have been at least in both, but let's speak about the first case. So the first case was about Take-Two Interactive. How much predictable it was that Take-Two Interactive will move on with legal claims. The media were reporting in 2021 that Take-Two Interactive was very active, in fact, in the process of taking legal steps against whom I will quote it. Over the past year, Take-Two has been on a rampage trying to file trademark claims against an array of companies and products. According to the US Patent Office records, the disputes were targeted at businesses using generic words like Rockstar, Star Rocks, Mafia, Social Club, among others. So you see, it's an example when the important player on the market is under the wide campaign of taking legal steps to protect their IP, or at least to protect the territory and the usage of descriptive words. In having such a circumstances as the background, releasing a title, It Takes Two, and trying to register it as a trademark has been risky. And as we know, it has faced the claims. Issue about the proportions to the scale of your venture, on the other hand, I would consider on two aspects. First, the territory, meaning the markets the game is intended to. And second, it would be the budget that the game has, the game production has. These two things are on one side, and the proportion on the other side would be the activities, the awareness, and the contribution to IP clearing. So if we have a game that has a big budget and lots of markets to be released on, probably it would be a good management assessment to invest also in IP clearance. However, if our game is intended only for local markets, probably the business wouldn't take decision to be checking faraway jurisdiction and searching legal databases in other countries. So that's, in short, how I understand managing the process. It should come from the business, although we lawyers are part of the team that supports the decision takers in the proper management of this process. Okay, second pro tip that I would give in good practices in IP clearance would be to start this process and address the proper actions on as early stage as possible. It's obvious, it helps saving money, it saves the producers from unnecessary changes in the last moment, and it gives less disappointment and bad news to the publicity. Third tip would be to be extra care with aspects that relate to the age rating and cultural differences. So especially about cultural differences, it's worth to remember when you are going to, with your game of course, to the jurisdiction that are far away from this, what you are familiar with as the game production studio. From our practice, we know that even experienced game makers can be really surprised how they imagine the location on faraway jurisdiction should look like, how to locate the game. And then the surprise is very big once they ask for the advice, a consultant on culture. You could be surprised how for us, European Union, words or descriptions that maybe sound Asian are not Asian at all for Asians, and we believe it is going to match to their culture, and in fact, it doesn't at all. Cultural consultations are also important when the game producers want to be safe from not causing any misappropriate associations. It's something that the business really puts lots of attention when they are locating the games. And this is what we are working on daily basis, supporting not only producers, but also working with cultural consultations teams from foreign jurisdictions. Okay, and then another tip would be this, what I've been already mentioning at the beginning, which is trademark. Really, trademarks are dangerous, and these two bad scenarios were actually very close to trademarks. We need to keep. I was thinking how to approach this obvious fact in this speech. And I would say what I mean by clear against the trademark databases. I think for some aspects it's quite obvious for everybody. Okay, we need to check the trademark databases if we want to register our own trademark, if it's maybe available or maybe not, and if it's not really available, how to adapt our descriptions or names to be possible to be registered and not to be interfering with rights of others. But that's not the only approach that is accurate and relevant in this situation. Definitely we should clear the trademarks, meaning checking trademarks databases for the content that we are acquiring from others, or licensing or buying already created content, because that's our risk as the game producers, if this content will be in fact fitting for our purposes, and if we are going to be able to use it in the games and on the market. But I would say even further, we should clear against the trademark databases all content, even our generated from scratch, because we are not living in the vacuum, as I was saying at the beginning. And sometimes studios believe that they have really invented something very autonomous and original, and they might be really surprised at the late stage that their plans must be changed only because the trademark databases are showing records that are protecting already others. So that's super important. And then the last tip, in fact, that I have prepared for today would be quite legalish, I'd say, is to make sure that the studio, or even us as lawyers working on IP clearance, that we take care that there are IP clearance policies and procedures. It's good to have written rules. It's good to have written know-how on that matter. It's good to have teams that are prepared and trained, and it's good to implement these procedures throughout all process of game production. Because the process is very dynamic and lots of people is involved. And only once we get teamwork, we are increasing our chances to be successful. So, yes, and what these policies and procedures may be covering, which areas? From my experience, I would say what is really important and practical for the clients. Because not always they ask lawyers to be checking and clearing every possible asset, but then there are some people who are doing the back office work at the client's studios that they should know how to procure and how to acquire copyrights. So they should know not only how to fill in the contracts that we are drafting for them to buy copyrights, but they should also know how to read and procure for the ready-to-use assets in the libraries, how to check the terms and conditions. They should also know how to draw inspirations when they are creating their own assets. They should know how to check trademark databases at the early stage on their own, because not with everything they are asking us lawyers to be consulted. And also what is very important from my experience is to draw attention or keeping track and gathering evidence of the process of creation. Sometimes it's necessary to prove on later stages that in fact there has been a creative process in the studio, and it's good to keep track of that for the future needs and for the purpose of having to show the evidence that the works were in fact made in original way. Okay, in fact that's all 5 tips I've prepared for today. I hope they are, say, clear, and I hope and I believe that they are useful, especially for those who are really participating in the production and IP clearance of video games, because yeah, I believe they are summing up to make games that are successful, that reach the market, and that brings satisfaction to the players without unnecessary stress for the game producers. Thank you.